Okay, we're very happy here at the NAACP DeKalb Criminal Justice Committee to have Ann Colloton of the Georgia Justice Project to speak to us about their work. And I'll say I've known the Georgia Justice Project and attended meetings that they presented and so forth for probably at least 15 years, maybe longer. And they do a great job, and we'll hear some of their important work tonight. And I'll just say, let's see, I wanted to say a little bit about Ann Colloton. Uh, let's see, you may have seen this already went out, but just uh, we were going to have Dominique Harris, but he wasn't able to make it back in time. But she's going to focus on early termination of probation and voting, and we'll also answer questions about other areas such as criminal record clearing. And Ann Colloton is the Georgia Justice Project's Policy and Outreach Coordinator, and she's been in that position since 2019. And what she focuses on is grassroots, grasstops. I want to hear about that, and business community support for legislative change that removes barriers to opportunity for returning citizens. So, Ann, I'll turn it over to you. She's going to show some slides, and we'll have a chance to ask questions. And are you okay with asking questions or answering questions as they come along, or do you want to wait till you finish your first 20 minutes?
Anything you prefer is fine. And I can't always see the chat when I'm sharing the slides. So if I don't see something that's put in the chat with the question, just and feel free to interrupt me or just unmute yourself and speak. That's totally fine.
Okay, thanks.
So if everyone can see that, okay. Is that looking all right?
Looks good.
Okay. All right. Well, thank you for having me tonight. I am going to talk about the Georgia Justice Project. And before I kind of get into what we do, I wanted just to give some context of the criminal legal system in Georgia, because I think it just kind of sets the stage for why it is we do what we do. And then talk about voting rights and early termination of probation for people with a felony record in Georgia. And again, about our services. So here we go. Okay, so a picture is worth 1,000 words, and I think many of us know, right, that the United States is the incarceration capital of the world, but I think it's always good to start out with just some context, right, that we got some real problems here. So, and with the exception of homicide by firearm, our crime rate is actually very comparable to these other countries. So it's really not about our crime rate, it's about how we respond to crime and what we do when with certain behavior. So that's how we compare it to other nations. This is how Georgia compares to other states within the United States. So this is the rate of correctional control. And when we talk about correctional control, what we mean is anyone who is incarcerated or under some form of supervision. So in a prison or a jail or on probation or parole. So you probably can't read all the names on the side unless you have really good vision, but it's all the 50 states. Georgia is at the top, very much an outlier. Our peer states are marked there as well. So the red part of that line is probation. So that is the longest part, but it's not the only part where we lead the nation, sadly. So this is, again, just sort of a list of the top 10 or the worst 10 states, right? So we lead the country in the total correctional control. We lead the country in the number of people on probation, and then the rate of people on probation, and we're in the top 4 for incarceration rate. So, and again, this is not because of crime rate. Georgia's crime rate is 26th, so we should be in the middle of that pack on the previous graph, but yet we're at the very top. So again, this is just context so we know what we're talking about in Georgia and why we need to be doing some things differently. So it's important to talk about racial disparities because the criminal legal system is full of racism from the very beginning, any step in that process historically, and any step in the process from policing to decisions about who is arrested, who gets a warning, who is offered diversion and who isn't, who gets charged with a felony, who gets charged with a misdemeanor, how long are the sentences that are offered, you know, plea deals, et cetera, who gets granted parole, who doesn't. So again, crime rates do not explain these disparities. It's about racism that's embedded in the system. This is also just a reminder that when we talk about the criminal legal system and mass incarceration, incarceration is a huge problem, but it's really a case of mass supervision. So this is everyone who's caught up in the criminal legal system currently in Georgia. You can see about 3/4 of the people are on probation, not incarcerated. That 340,000 includes misdemeanor probation and felony probation. So about actually, let me do them. Yeah, about half are on felony probation and half are on misdemeanor probation in Georgia. But so just again, this is just background context that I think is important. So these are again just some numbers about who is incarcerated and where in the system. So when we talk about the criminal legal system, there's the front end, you know, like at the policing, arrest, prosecution, the middle section, and then the reentry, probation, parole, and the collateral consequences of a criminal record that can follow someone for decades and sometimes a lifetime into the future, creating barriers to employment and housing. So 1 in 24 people in Georgia is under some form of correctional control right now. And cumulatively, there's 4.5 million people in Georgia who have people who have a Georgia criminal record of some kind. And that doesn't necessarily mean a conviction. That is they were arrested for some fingerprintable offense. So it could be that they were arrested and it was dismissed, or they were acquitted, or anything like that, but they're in the system in some way with a fingerprintable arrestable offense. And so Georgia Justice Project. So our mission is to reduce the number of people who are under correctional control in Georgia and to reduce barriers to reentry. And we do that in 3 different ways. We actually provide legal representation to individual people. We work for policy change, and we do community outreach and awareness building about the opportunities for reform and opportunities for legal remedies related to those barriers. So I'll talk about more specifically about what we do, but just kind of this kind of arc again describes sort of the part of the criminal legal system and where we show up. So on the front end, we have holistic criminal defense that I'll explain more on the next slide, and then restorative justice, which is also a front end diversionary option that we work with. In the middle, we help people, anybody that we represent on the front end, we support them and their family during any time if they're incarcerated or during their sentence, and actually continue that support long into the future as well. And we provide a lot of social service and legal support to people who are incarcerated at the Mentor Reentry Facility, which is I think in DeKalb, pretty close by. And then on the back end, on the criminal records or the reentry side, we help people with expungement, early termination of probation, and then some warrant clinic. Well, actually, that would be on the front end, warrant clinic in the city of Atlanta as well. And then our policy change work really spans the whole spectrum of the criminal legal system, and I'll share about that as well. So whenever we do presentation like this, we like to talk about the importance of language and how we refer to people who are caught up in the criminal legal system. We don't like to use any labels that label someone a felon or an ex-offender or an inmate. We like to recognize that someone is more than the act that they got them caught up into the criminal legal system. So we like to talk about a person with an arrest or conviction record, a returning citizen, a person who is impacted by the criminal legal system, someone who is formerly incarcerated, words like that. So not just in the context of this presentation, but whenever we're around town and hear people use labels like that, we try to remind people of the importance of recognizing people's humanity. So in terms of the services that we provide, so again, I mentioned on the front end, we help people with holistic criminal defense. So that when we just do that, that is one part of our work that is focused on the Metro Atlanta area rather than statewide. So we represent people who have pending criminal cases, full felonies or misdemeanors in Fulton and DeKalb counties. And everyone who we take on, we're similar to the public defender that we help people who can't afford a private attorney. But what makes us very different is that we have very small caseloads. Everyone who is assigned a lawyer is also assigned a social worker to help support them and address any issues that got them caught up into the system in the first place. Like I said, we support them and their family for decades into the future, support them, make sure that they, once they're out of the system, they can thrive as much as possible, despite the barriers that they might face. And then restorative justice, Bert can probably tell you more about this, but we have a memorandums of understanding with DeKalb and Douglas, and prosecutors there can refer cases when a victim would like an alternative to the traditional legal system, the adversarial system, where they might be able to say, well, I just don't want this person to go to jail, but what I really want and need is to know why they broke into my apartment and stole stuff, because now I can't go to sleep at night. I feel like I have to move because I don't feel safe there anymore. And I want to know, well, were they targeting me? Did they just need money? What is it? And so if a victim is interested in that kind of dialogue, they can learn and get those answers to their questions, and also determine what accountability looks like, and ask for certain things that will repair the harm that they felt, that they experienced, and dictate the terms of the person's, the result of the person who caused the harm, what they have to do to take accountability for their actions. So I can put some links in the chat later, but if you know anyone who's in need of those services, you can refer them. And, we're a small nonprofit. We can't take every case that's referred to us, but we can certainly consider that. So on the back end of that spectrum, we help people with expungement. So this is sometimes called record restriction or record sealing. So this is a work in progress in that every year, hopefully, we're going to pass laws that will expand the options for people. But currently, used to be up until 2013. Well, even before 2013, there wasn't really any way, nothing you could do. But in 2013, we passed a law that allowed people to at least get arrests that didn't lead to conviction off of somebody's record. In 2021, we passed a law that allowed certain convictions that come off someone's record. So there are excluded offenses. Not every offense is eligible for that. But current law allows someone to restrict and seal up to 2 misdemeanor convictions 4 years after the date of their last conviction, and felony convictions that have been pardoned, which you can seek a pardon 5 years after the completion of your sentence. Many of those convictions are now eligible for restriction and sealing. And there's more options for people who have a criminal history that is related to being a survivor of human trafficking. And another option for that can help a lot of people who just have one
Ann,
conviction.
excuse me, Ann.
Sure.
Vic has a question, I think, or comment.
Sure. Yep.
Yes, and as far as the reentry program or the things that are minor convictions or even felony convictions, what rate do you have with the Georgia Justice Project to get them back to voter registry, being registered to vote?
Mm-hmm. Well, yes, good question. So just to be clear, expungement is not required in order to register to vote. So I'll talk more about voting rights later, but the only thing somebody has to do in order to be eligible to vote is complete their sentence, probation, parole, incarceration, and just re-register. Expungement is not related to voting rights at all, not necessary. So, yeah, and in terms of what percent of people, in terms of eligibility for expungement, 1.5 million people are eligible for expungement in Georgia. We are almost exclusively the only nonprofit in the state that helps people with expungement who can't afford to hire an attorney. So our 5 attorneys and 3 intake staff cannot help all 1.5 million people, unfortunately. So we do as much as we can, but and I think we have a pretty good success rate for the people that we can help, but we cannot expunge a record. There's always still prosecutorial and judicial discretion that is required from much of that. And so we try our best to have good working relationships with prosecutors and judges so that they'll approve the petitions that we submit. But unfortunately, we can't always control that. As I said, this is a work in progress. The long-term goal on the policy side is that we will pass something called clean slate, which is what many states have, where there'll be a computer query that says someone has this conviction this many years ago, it's eligible, click of a button, boom, it's restricted and sealed. That would be the ideal world for everyone. Prosecutors don't like having to sort through this paperwork when it's something that's old. It would take the burden off of us when we have 1.5 million people. It would help the individuals. But we have a ways to go before we can get that with infrastructure and other things in the state. But that is our ultimate goal, that we will get there. And then one thing I'll just mention, in Georgia, I don't know if this is too much in the weeds, but there's a 2-step process in Georgia. There's restricting the record in the GCIC database, the Georgia Crime Information Center. This is the GBI's records. That's restricting it. But then you also have to seal the court record, because private background check companies get them through the digitized court system. And so if you don't do that second step of sealing the court record, then you really aren't helping somebody with removing barriers to employment and housing, which is really what expungement is designed for, is to help remove those barriers. So there's more information on our website. I can put the link in the chat. So how do we help people? Somebody thinks, okay, I need this. How can we help? So this is a flyer about an event that we have in DeKalb coming up in April 13th. It's a partnership with Goodwill and the prosecutors and several other partners. And it's kind of a streamlined process. So rather than submitting one petition at a time for an individual, this event, if it's done right anyways, the prosecutors will streamline that process and be able to help a lot more people through this event than we could if we did it individually. So one thing to note, again, the inefficient process that we'd love to get past is that wherever someone's record is, like if I have one case out of Chatham County, one in DeKalb, and one in Colloton, I have to do that 3 separate times. I have to address my case in Colloton and DeKalb and Chatham all separately, because it again, it's approved by the prosecutors and judges in those counties. So again, that's just the way it is what we have to do. So this just handles cases that were resolved or originated in DeKalb County. But for other cases, so this is all the different ways that we can help somebody with expungement. So our general intake that helps people all over the state of Georgia is, the first step in that is to attend a First Friday presentation, which is a virtual presentation. We do the first Friday of every month at 10 a.m. And it's about a 45-minute presentation about what's possible, what's eligible, what isn't eligible, things like that. And then from there, people can apply for services, and then we will consult with them. Excuse me, sorry. So on our website, which again, I think it's at that QR code, or I can put it in the chat, people can sign up for First Friday. Anybody can attend, whether you have a record or you just want to learn about that. And then the individual can apply for help from there. Similar to that DeKalb summit that I showed on the previous slide, we do other summits like that around the state as well. And sometimes we do educational events where we just speak about expungement. And then the most exciting way that we're helping people is certain counties, we have a desk, or second chance desk, which is similar to an expungement summit, but it's on a more regular basis. So in Cobb County, there's a weekly desk. Every Friday morning, we're in Cobb County, meeting with individuals who have a Cobb County record and working with the prosecutors and judges there to restrict and seal records every Friday. Athens and Augusta, we do that once a month. So The other big part of our work, besides the expungement and defense on the front end, is helping people have a long probation sentence. So Georgia, as you remember from that first graph, has very long probation sentences and a lot of people on probation. So many states cap their probation sentences at 2 years, 3 years, maybe 5 years at the outside. In Georgia, 40% of our probation sentences are longer than 10 years. So a couple of years ago, we decided, well, what can we do to change that situation? And we thought about introducing a bill that would put caps on probation sentences, but we weren't sure it would pass. And we also kind of feared that if we just capped probation, when judges are used to putting somebody on probation for a long time, that might just then cause them to start sending people to prison for long periods of time. So we thought, okay, something in the middle that'll get them used to the idea that long probation sentences aren't necessary, is to provide for early termination of probation. So there's a new law. This is the criteria. It says if you've been on probation for at least 3 years and you meet these 3 other criteria, which is no new arrests other than non-serious traffic offenses, have not had your probation revoked in the past 24 months, and paid all restitution, you're eligible. You might be eligible for early termination. So in restitution, I want to be clear, does not include fines and fees. Restitution is just what is court ordered to be paid to a victim. Many cases don't have restitution at all, but if you do, that does have to be paid before you're eligible for early termination. So, and this is related to voting. So I just want to point it out, that connection, that there's 175,000 people who are on probation currently. And that is the vast majority of people who are disenfranchised, legally disenfranchised from voting, are on probation. And so this bill will help people get off probation sooner, which will help in so many ways in terms of employment and housing and other barriers, but it'll also impact voting rights. So if someone thinks that they meet that criteria, and I just want to point out too, probation and parole are often confused. So probation and parole, even though it's the same officers that supervise someone, the legal status is very different. So probation, or parole rather, is a function of the State Board of Pardons and Parole. So if somebody is on parole for 15 years, unfortunately right now there is not a mechanism to terminate that early. There are some, but this is different. So if a person has to be on probation, which in Georgia is not just an alternative to incarceration, sometimes it is, but sometimes someone might be sentenced to 10 years, serve 5. So they're in prison for 5 and then have probation for 5 more after that. So, but again, what I'm talking about right now, early termination of probation, is just about probation. So what should somebody do if they think they might qualify for early termination? So just to be clear, you don't need a lawyer. You don't need a lawyer. But the first step is to call your probation officer. And if you don't know who your probation officer is, because you've been put on non-report. So that's the other thing. Most people who've been on probation for 3 years and are doing well are not even being supervised. I don't think people know that. Many people don't know that unless you've been on probation, but frequently people are on non-report or unsupervised status. And so they're not checking in with the probation officer. No one is following them at all. So there's no public safety benefit to that status, but it is still, that legal status is still hanging over someone's head, causing all sorts of barriers, including keeping them from voting. So if they don't know who their probation officer is, they can just call the probation office in their county and speak to the coordinating, I think it's the coordinating chief, and request early termination. And we have some information on our website that says, like, these are the questions to ask. And then if they continue to have problems, they can reach out to us and we can help somebody and walk through that process a little bit better. So I think my next slide, is about voting, just because this kind of links with voting here. So today I really want to focus on who is eligible to vote, because there's 450,000 people who have a felony record who are eligible to vote. But I also want to acknowledge the history of felony disenfranchisement and the people who are not eligible to vote. So there's about 200,000 people in Georgia who are currently disenfranchised because they're serving a sentence for a felony conviction. about 2/3 are on probation, 1/3 are incarcerated. The roots of that go back to the 13th Amendment that was passed in 1865 that outlawed slavery except as punishment for a crime. So, as I'm sure you know, black code laws were passed soon after that in order to re-enslave basically the people who were previously enslaved, to lease them out to private companies through the convict leasing system. Soon after that, that's when felony disenfranchisement was added to the Georgia State Constitution to remove the voting power of formerly enslaved people. So that's the context for which felony disenfranchisement exists today, and mass incarceration for that matter, when you talk about policing and sentencing laws. That's the foundation upon which everything is built. So it's important to acknowledge that, but I want to kind of shift gears toward, for today, who is eligible to, because I think we're not going to change that law of felony disenfranchisement until we engage the people who can vote. So just a reminder, this map is just a reminder that every state has different voting laws. So Georgia is one of those states where your rights are restored upon completion of your sentence. Some states are more strict than that, some are more lenient. But when we hear on the news, or see on the news rather, when people are getting arrested in Florida for voting when they thought they were eligible, that fear crosses state lines, and it was a very effective scare tactic. But the law in Georgia is different than Florida law. But so this is just a reminder that every state is different. So we're going to talk today about Georgia law specifically. So who is eligible to vote in Georgia is anyone who is not currently serving a sentence for a felony conviction. So, and as soon as someone's sentence is complete, their right to vote is automatically restored. They don't need their record expunged or pardoned or any paperwork or anything special other than to register. So the right to vote is automatically restored, but they do have to take that step to register or to re-register if they were previously registered. Just like someone turns 18, they can have the right to vote, but they have to register to act on that right. So, and when we talk about sentence completion or being off paper, sometimes the term that we use, that means that they have completed any term of incarceration, probation, and parole, including any period of non-reported unsupervised status. And then a big exception that a lot of people don't know about that affects 40,000 people in Georgia is that if somebody is serving a felony first offender act or conditional discharge sentence, they can actually vote while they're under sentence. They do not have to wait until that sentence is complete, because unless that status gets revoked, it's not considered a conviction. Even though it's a felony sentence, it's not considered a conviction. And so they don't lose the right to vote. That's 40,000 people. If somebody's in jail, they can register to vote and vote as long as they're not serving a sentence for a felony conviction. So if they have a pending felony charge, that's still fine as long as they aren't incarcerated for a previous felony that or are awaiting transfer to the state system after being convicted. And misdemeanor sentences don't affect voting rights at all. So just a reminder that anytime a person's sentence is complete, all they have to do is re-register and they can vote. So, especially with what happened in Florida last election cycle, it always comes up, people ask about fines and fees. So I like to clarify that. So in 2020, the Secretary of State published new information on their website that clarified that. So it does say you have to complete your sentence and pay your fines. But it goes on to say that fines that were imposed as a condition of probation are automatically canceled upon completion of probation. And in Georgia, that's virtually everyone, if you have some kind of supervision afterwards. And it also goes on to say that your felony sentence is considered complete even if you have outstanding monetary obligations such as unpaid restitution, fees, costs, and surcharges. So again, money stuff doesn't matter in Georgia. As long as your sentence is complete, you can vote. These are just some examples of materials that we have. If you do voter outreach with other organizations or with the NAACP, on the right side of these off paper cards, they're two-sided. They're just little postcards. One side is about probation and the other is about voting, since I described before how those are linked. On the left, the white, that's a poster that we can share, or you can actually print that from our website and put them up in any business, church, storefront, wherever you think people would see that. We're also in the process of getting some yard signs printed. We just don't have those quite ready. But if you could use these, we'd be happy to send you as many as you could use. And then the last thing I want to talk about is our policy priorities. So the expungement work that we do and the early termination of probation work that we do is a result of being able to pass laws that remove some of those barriers for people who are caught up in the system. So excited that today, Tuesday, just yesterday, 3 out of these 4 bills passed their committee in their chamber and are in the final steps of the process. They just have to get a vote on the House floor, on the House or Senate floor. You get through the Rules Committee and get a vote on the floor, and then they will become law. So we have until March 28th for them to finish those steps, but I'll just outline briefly, if I'm not running out of time, our policy priorities for 2024. So first one is an occupational licensing bill, Senate Bill 157, which is, we frame our things in terms of workforce, right? It's a criminal justice reform, social justice bill, but if it's framed in terms of workforce development, people get it. Legislators, conservative legislators get it and are more willing to support it. And so this will help people get an occupational license, which is like, good careers, well-paying, they have economic mobility. They're not just a job at McDonald's, but they're really careers. So this will change the way the licensing boards can consider a criminal record. It will narrow what they can consider. Right now, people have to disclose everything under the sun, no matter how long ago, if it's relevant to the job or not. And one of the biggest deterrents is that people don't know if they're going to be eligible. And so somebody might say, I want to become a nurse, I want to become an HVAC person, but they don't know. And the technical colleges who are advising these students don't know either whether they should invest all that time and money to get their education, because they might just be turned down after spending all that time and money. And so this will require a pre-clearance process. So someone can say, I would like to do this. Is my record disqualifying, or would I, if I complete all the training, will I be able to get a license? And then it will help, and then it'll provide some due process things in there. So if someone is denied, they have a right to an appeal and things like that. That is not in the process currently. Also in that same bill 157 are some things that will expand expungement, particularly misdemeanor expungement, remove that cap from 2 misdemeanors to more misdemeanors. And then House Bill 909 will improve the First Offender Act, which is Georgia's original second chance bill passed in 1968 that allows somebody who had an isolated mistake, they're promised, if you do everything that said here, it won't show up, it won't be a conviction, and when you go to apply for school or housing or anything, it won't show up. That's what people are promised. But background checks have evolved in the last 50 years, and this law hasn't kept up. And so this will require sealing. Remember, I talked about the 2-step process, the restriction and sealing. So many people come to us because their record was restricted but not sealed, and so years later, this thing is still popping up that they were promised 20 years before should be gone. And so this will require the sealing step at sentencing. Our restorative justice bill, unfortunately, did not cross over, so we're still looking for ways to make that happen. But that would make the discussions that are happening in the restorative justice process privileged so that it can't be used against someone in court, which is, that kind of open dialogue and confession or acknowledgement of wrongdoing is essential for that process. And so that's why it's important that it's privileged. The last bill is House Bill 926, which will facilitate people getting their driver's license reinstated. There's 105,000 people every year who get their license suspended, not because of dangerous driving, but because they missed their court date in traffic court. And so this will make it much easier for someone to get their license back so that they can continue to drive to work and support their family and pay off the ticket if they have one. And it'll also reduce or eliminate actually the reinstatement fee for low-income Georgians for whose license are suspended for anything. So those are our 3 bills. If you're interested in that, you can sign up for our action alerts and learn more about and learn what's happening in every step.
So, and what is the length of time for that driver's license, one that you had there?
What do you mean the length of time?
So if they have done and completed their services and whatnot, the license reinstatement can happen right away, or do they have to wait a certain amount of time?
Right. Well, that bill will only address people who had their license suspended for an FTA or failure to appear. So if their license was suspended for missing traffic court, like, you get the speeding ticket or rolling through a stop sign, whatever, and then you don't pay the fine right away, but you want to go to traffic court to contest the ticket, but you missed the court date, right? Because they don't remind you. And then 6 months go by, you don't realize your license is suspended, whatever. And but or you might say, oh, I found that ticket in my junk pile. Oh my gosh, I didn't know that. And so then you re-engage the court, you call them up and say, I missed my court date. I'd like to reschedule. As soon as that person calls and says, I'd like to reschedule, that's when their license will get reinstated. So it's that first engagement with the court after missing the court date.
Okay.
And so it doesn't, and I think it might just happen that first time. Like if somebody then misses the court date again and again and again, it's not an automatic thing like that. But the first time it's supposed to be, if this passes, as soon as they call the court again.
So let me welcome Denise Peterson and Frida. I think I know Frida's last name, but I can't call it out right now. Welcome. We're at the question and answer part, and we are recording or have recorded this, so we'll be able to go back and look at it later. But anybody wants to ask a question or?
Okay,
I have a question.
go ahead.
Well, I was just going to say or ask, in terms of the policy work that you all are doing, could you, I guess specifically, I'd like to know, are you all looking to change policy to make certain of things like arrestable is a word, but in terms like not speeding tickets, like driving without a license or like suspensions and things, some of those,
Right.
I think we're calling it like more poverty infraction. When you all are working on like policies, that what you all are aiming to do, or is it a different direction? I hope that made sense.
No, very much so. Great question. Often it's called criminalization of poverty. So there is no shortage of things wrong with the criminal legal system that need to be reformed. So like,
agreed.
we would love to do it all. We can't do it all at the same time, but so decriminalizing the traffic code, which is one thing you alluded to, is a dream, and not a dream, but like a goal. And I would say in the not too, who knows how long it'll take, but I think we're looking at that in the short term as a priority that we can seek. Because, the license suspension is just one small part of that whole problem, right? And then other things, just like, yes, powers to arrest and why people are arrested for certain things rather than referred to treatment or, housing providers and things like that. So, and some work has been done with that. It's by different organizations at local levels, like to change certain things to citations as opposed to arrest on certain offenses. But yes, certainly could be more done at the state level.
All right, awesome. Thank you.
And I will say that we have noticed that I've been at GJP about 4 years. legislators are much more open-minded than they used to be about understanding redemption and the need for reform on the back end, that they understand that people change and that people need to help getting back, that we can't keep somebody down forever, and that's hurting all of us when we do that. It's harder for them to change their thinking about somebody on the front end. And so we're trying to work on that narrative change on the front end, because it's a harder battle though. But I feel like because we've done some of that narrative change in the back end, I think we're positioned to help try to do that on the front end going forward.
Oh, that's good to know. Awesome.
So, Ann, you did allude to my being connected with restorative justice, which some people know about this. I'm actually on the committee that has responsibility for that program, and we were sorry that the very good director that you had there decided to go take a job somewhere else. So I know things are a little bit slow, maybe, but well, I wanted to, we did hear about the bill that let's see, which one is that? That's House Bill 1184, and it does seem like a great way to at least get it. I mean, if I understand, see if I interpret that right, that if you do a restorative justice process, whatever you say, back and forth to the both the powers who have the district attorney or whatever, or to the person who was harmed by somebody, that will not go against you if you decide later that you're going to go to court or something like that. I mean, that's the basic idea of the bill, isn't it?
Yes, correct. It'll make those things privileged, which is kind of in layperson's term, kind of like confidential, but it's more of a legal term. So, but it doesn't, like, for some people, like, but wait, like, and maybe not anybody here, I don't know, but like if somebody says, in the context of, yes, I broke into your apartment, and by the way, I also killed my mother and buried her in my backyard, confessing to that, that statement of confession is still privileged, but that does not preclude the police from digging up in your backyard and finding that evidence. So just so that, for people who are like, but what, like, how come we, if somebody, acknowledges something, there should be, so it doesn't preclude that, but it does, in the general sort of justice process, you have to acknowledge what you did wrong to the other person, and you won't do that if there's that risk. Like a lawyer wouldn't advise their client to admit that, even though that's really what is healthy for everybody, right? Is to have that kind of dialogue.
So I guess just wanted to check and see if you had any idea of the best way that we could promote that as a law, that or do you know anything about what's the is it resistance, or is it just something new that hasn't had a chance to be worked on or something like that?
Yeah, the resistance, it is not a problem of resistance. It passed the House unanimously. It just ran out, or the committee, it just ran out of time, unfortunately, last year and this year. So we're still looking. There's this sneaky thing you can do in policy world of like attaching your bill to another bill that's already crossed over. So there is an option for that, and we're looking into. So it's still possible that something in the next 2 weeks could happen with that. It'll just have a different bill number, but if you're signed up for our action alerts, Bert, you would hear about that for sure. If that happens, we'll make sure our restorative justice partners hear about it.
Okay.
And I think, there's a lot of, I think there was I'm trying to remember the number, 70, 41, some group of pastors who signed on to support the legislation as well. So along with like 4 different crime victim survivor groups as well. So that was very helpful. So again, it's not resistant. That was just a matter of ran out of time, unfortunately.
So, and I'll just maybe want to mention, we're the Criminal Justice Committee, so we should be aware that our state is about to kill somebody who's intellectually disabled. Just if we can hold him and family and all that in the light, I appreciate it.
Mhm.
There are vigils that are happening. I'm not going to be able to go, but there are things you can do.
Mhm.